Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to Aaron Knapp, unplugged.com, my new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe, and share this with someone who needs the truth. We're building something real here. We're building something fearless, and we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Plug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain.
All right there. Good morning there, Lorraine. Hey, it's Aaron Knapp here. We're here today, this morning, in a lot of ways. I had a plan. We were going to address a lot of different things tonight, but one of them is going to be our recent podcast by our friends over at Madhouse. Like, gotta appreciate the continued advertisement. I must say, I have to imagine that's getting me a lot of hits. That being said, here it is about 2:00 in the morning. I want to thank everybody for coming out tonight. Hey, if you're just getting home from the bar, 1:39 in the morning, I hope you had a good night. Well, shit, you probably didn't. Well, maybe you did. You're coming home alone. That could be a good thing. But tonight, we're going to talk about a bunch of different things. Not so much about that podcast, even though I know it was kind of pissy and Tia was like, all night long, but whatever. Like, right, we're going to do our thing. But we're going to talk about first, we're going to talk about the city. We're going to talk about how they're doing what they're doing. So all the way down, the city has been picking sides against the law. And what this episode is and why it matters tonight is it's not a rant, because I know some people are already typing, right? It's like it's not speculation, it's not theory, and it's definitely not just one side of the story. The episode exists for a much simpler reason. The documents exist, the engagement letters exist, the approvals exist, the ADA notice exists. The silence is deafening. It's the kind of silence you only get when nobody wants to explain what is actually in the paperwork, right? So when you lay those records down next to each other, not in isolation, not cherry picked, but side by side, right? What you get is the pattern that emerges is not subtle. It's not accidental. It's not something you can fix with a press release or a value speech or read from a podium. This episode tonight is about, or this morning, I guess I should say, is about conflicts of interest that have moved well past the hypothetical stage. It's about public officials who wear multiple hats at the same time. And I've called this out in multiple areas, but tonight's somehow they insist that nothing touches, right? The decision maker, the defendant, the witness, the authorizer, the approver, all at once. So we're just told, just trust the process, folks. Trust it. You'll be all right. All right. So it's also about a city that loves to remind residents that the rules matter, right? Procedures matter. Compliance matters. right up until the moment that those same rules apply to the people at the top, them, right? Then suddenly they're like, look, it's flexible, it's contextual, it's misunderstood, or my favorite, under review. So, yeah, it's about what happens when federal disability law is treated like suggestions instead of a mandate. It's when ADA requests are unanswered for a year. It's when accommodations turn into confrontation. It's when silence is mistaken for compliance and irritation is mistaken for authority. Now, nothing you will hear tonight's rumor, nothing you're going to hear is anonymous, nothing you're going to hear is sourced to vibes or Facebook comments, right? Everything's discussed. It's grounded in records that you can read for yourselves. Signatures you can verify, approvals you can find on file, and laws that apply whether officials want to like it or not. And you can go looking for a spank. You can look anywhere you want, but you're going to look in the wrong place. Because if you're looking for receipts, stay right here, folks. Because that's what we're doing here tonight, is giving receipts. I mean, I've seen what they've done lately, and it's kind of scary. We look at somebody like, let's say, a Rosenbaum. They're hiring counsel for each other, folks, and they pretend it's normal. So let's just start with probably the most clearest and uncomfortable conflict in all of this saga. Not because it's one that's inferred. It's not even debated. It's not buried in the footnotes. It's literally in black and white. It's signed, it's approved, it's placed in the city's own records. Jonathan Rosenbaum, Ironsides himself, engaged to represent former police chief James fucking McCann in not one, but two separate matters. Me and Mr. Petty. So one's a federal civil rights action brought by none other than yours truly, me. The other's related matter, right? Petty matter. In both cases, the engagement letters do something very specific and very important y'all need to remember. And that's they identify James McCann as the individual client in the corner of everything. Hold on, I got to see what this says. Yeah. Oh, wait, hold on. Sorry, I apologize. Oh wow, folks. I'm gonna say this. I could be talking to somebody more important than all y'all, but I'm not gonna. So what we're gonna say is this: is that we're gonna go back to so matter brought by me, the other matter is brought by Patty. In both cases, the engagement letters do something kind of specific, and it's very important. They identify McCann as the individual client, not the city, not the safety service director, not the mayor's office, James McCann personally, ex-chief. Letters are explicit about this. The scope is the individual. The retainer is the individual. The billing is the individual. The city's not named even as a client, not named as a co-client, not named as an indemnifying party on that paperwork. And that's important because this is not municipal defense. This is personal representation. The distinction is not academic, folks. It's the entire legal dividing line. Under Ohio law, indemnification, as I said earlier, is very important. It's what allows a municipality to lawfully step in and defend an employee. Indemnification is like not automatic, though. It has to have findings. It requires Riley, the law department, to step in and check it out. It requires a determination that the conduct fell within the scope of employment and was not malicious, reckless, or in bad faith. And it was. And then after all those determinations are made or whatever, they can be assumed, they have to be made. They must be made by people who are not conflicted, meaning someone other than in the city. So that brings us to the point nobody wants to say out loud. Jack Bradley and Ray Carrion are named as defendants in that same federal litigation that I brought, arising from the same nucleus of the facts, and yet they're the same people that approved the process that resulted in Mr. Rosenbaum being retained to defend McCann personally. And I'm fairly certain they were both named in Guerin's suit, which means the engagement letter from me, the federal case bears carry-on signature and Riley's signature as approved to form. It's not disputed. It's record. Now, that's not just about appearances. It is about vibes. Or even about vibes. It's about governance. The Ohio law requires public officials act in the best interest of the public entity, not in the best interest of their co-defendants. So when an official who they themselves happen to be defendants authorize public funds, public processes, yeah, okay, but not in mine, Guerin. Public funds, public processes, or institutional approval to secure legal defense or another defendant in the same case, the issue stops being political. It starts becoming legal exposure. That's where Rosenbaum problem gets bigger. Patrick Riley is not a neutral administrator signing paperwork in a vacuum. Patrick Riley has an established professional history with Rosenbaum. He approved Rosenbaum's engagement here, and at the same time, Rosenbaum is not merely an outside lawyer floating out of nowhere. He's currently a litigant in the Nancy Smith case alongside the city of Lorraine itself. Let it sink in, folks. The city's chosen counsel for defending its former police chief is one federal civil rights case, is simultaneously an opposing party or an aligned litigant in separate active litigation involving the city. That alone should have triggered some sort of heightened security, some independent review, full transparency. Instead, it was treated like, hey, we're good. So apparently nobody thought it was worth pausing to ask whether hiring a lawyer who is actively litigating against or alongside the city in another matter might complicate things. Nah, including with me and Garrett, so you got three. Or maybe they did ask and just didn't like the answer. The city has never really produced a lawful indemnification resolution for McCann. I asked for it, right? I sent it. There's no council vote. There's no statutory filing. There's no written determination that his alleged conduct fell within the scope of employment as required by Ohio law. None. Not a goddamn one. Not one. What does exist is a paper trail showing defendants, being Riley and Mr. Ray Carrion, approving defense arrangements for one another. And the law director, Patrick Riley, signing off on form, despite his own entanglements and despite the overlapping litigation context involving the same outside counsel. Mind you, he's a witness in that case. So at some point, this stops looking like oversight, starts looking like institutional alignment. The courts are very good at recognizing the difference. This isn't some misunderstanding, some gray area, some conflict that exists whether anyone acknowledges or not, right? It is actually there. Whether you want to say it's true or not, whether somebody else wants to say it's true or not, it's there. And it's not neutral governance. That's alignment, right? So when we look at this kind of crap, we go, all right, fine. Riley recused himself as a witness signing the motion anyway. So in the criminal trial against Guerin, Riley had to recuse himself because he was a witness. That's where that paper trail stops being awkward and starts being a little bit indefensible, right? Pat Riley, he's a recused party from the petty criminal matter. So he's listed as a witness. That's not rhetoric. It's just fact, procedural fact. The state of Ohio acknowledged the conflict and brought in outside counsel, Patrick Ward, to handle the prosecution. So recusal happened because Riley's involvement was not peripheral, it was material. So you recuse as a witness. You're not just stepping back from that role. You're being formally recognized as someone whose actions and knowledge is part of the evidentiary record, right? So now hold that fact in your head and kind of look at what happens next, right? Despite that recusal, despite being identified as a witness in a related matter arising from the same factual universe, Pat Riley signs the files that the city of Lorraine's motion for definite statement in the petty case, civil case. His signature's on the motion. I see it. His name is on the pleading. I see it. He's not lurking in the background or hiding or giving it to the low guy on the totem pole, right? He's the law director advancing the city's litigation posture on the record against Garen, in which in the case he's the witness. Okay. Maybe I don't know shit, but I do know this. Like, that's not a technical inconsistency. It kind of seems like a conflict, sort of in ink. And again, that motion itself attacks the complaint as vague, rambling, and scandalous. It argues that the defendants cannot reasonably frame a response. It seeks to narrow, sanitize, and control the whole narrative. Like, I feel like before discovery ever even begins, it's a classic defense strategy, right? It's also exactly the kind of advocacy that a recused witness is not supposed to be engaging in. That's the big deal. You cannot be too conflicted to prosecute and simultaneously neutral enough to defend. So Rowley's not just a distant administrator on this. He's reviewing filings after the fact, right? He approved the engagement letters. He signed off on defense arrangements. He communicated with parties involved. Those aren't actions that are like, these actions are not abstract policy decisions, right? They are what we would call events that may be examined, questioned, and testified to. This is why Riley was recused in the criminal matter against Petty in the first place. And the question writes itself, people. If Riley's involvement was sustained enough to require recusal when the state was prosecuting, how is it appropriate for him to now draft and sign motions in civil litigation against Petty or on behalf of the city, attacking the same factual allegations that the same underlying conduct and conflict existed? The law doesn't recognize a part-time witness or a part-time conflict. And as we said multiple times before, he finally got Patrick in. If you were recused now, if you're conflicted now, you're conflicted then. So it really just boils down to conflicted. And that's the one part this whole story is going to keep coming back to, is conflicted. Ethics rules exist for precisely this reason, to prevent the kind of role switching we see going on right here, right? A lawyer cannot serve as both advocate and witness in matters where his own conduct is at issue in Riley, because doing so contaminates credibility, distorts discovery, undermines the integrity of the proceedings. The courts don't like it. They disfavor it. And defendants will regret it pretty much later. And municipalities, they almost always pay for it. It's not an academic complaint, folks. This is the state already acknowledged the conflict once. It cannot be memory hold now because the city prefers Riley's pen to independent review. When Riley signs that motion, right, after having been recused himself as a witness in a related criminal proceedings, the city forfeits any claim and that this is ordinary law department business, right? What becomes instead is a documented contradiction. And the contradiction is that they don't just disappear when they become inconvenient. What happens is they get examined. And that's where the problem comes in, because it's not an isolated lapse. It's not just one mistake. It's not a one-off. This shit's confined are not confined to one office or personality. What we see is a recurring theme throughout it all. We continue to see at every level, right? In government, the same individuals rotate between roles and as decision makers, witnesses, advocates, approvers. System simply provides or pretends those roles do not collide. You see them on other boards. You see Dan Petticourts. You see people on boards for the Port Authority. All this. The idea that conflicts are acknowledged when they're unavoidable normally, but quietly here and learning they're ignored when they become inconvenient. Recusal is treated as a situational issue rather than a structural one. So transparency is invoked rhetorically and abandoned procedurally. So the result is governance culture where accountability is conditional, right? Where rules are enforced downward and flexibility is reserved for upward. Now, this is where the public is asked to accept contradictions that would typically never be tolerated from an ordinary person and citizen in regular life. And that's not how the public trust is preserved, right? That's how it erodes. People tell you, fuck off. So when it's about the ADA a little bit, there's been a year of silence between my first ADA complaint and the rest. It's a violation, no matter when I look at it. Because this is where the city's posture stops being questionable and starts being indefensible. We look at the fact that this is not about misunderstanding. It's about not even about a clerical error. It's about someone missing an email? Or is it about what happens when a public entity is put on clear notice of a disability accommodation request and does absolutely fucking nothing with it for over a year? So I submitted a written ADA accommodation request over a year ago. That request was not denied, wasn't responded to with questions, wasn't followed up on. It was just fucking ignored completely. And federal law doesn't allow that. Title II of the Americans with Disability Act imposes an affirmative duty on public entities, and that word matters. Affirmative, right? Affirmative. The obligation is triggered by notice, not by convenience, not by whether the officials like it or like the person making the request. It's not whether accommodating that person feels politically comfortable. Once notice is given, the city has a legal obligation to engage in an interactive process, meaning silence is not a holding pattern under the ADA. Silence is actually considered non-compliance. For a year, non-compliance. The law is explicit. Public entities must provide reasonable accommodation and ensure that effective communication is made. They may not require unnecessary medical verification as a gatekeeping tactic. And they may not publicly discuss a person's disability in open meetings. They may not confront or yell at a disabled individual for asserting protected rights. And they may not wait a fucking year and then pretend like none of it ever happened. That's not my interpretation. That's federal law, folks. On December 18th, Jay Shore, who was a familiar person with the city of Lorain's failure to follow ADA law, sent me a letter to send to the mayor, along with my own letter, sorry. What it basically said was, in plain language, is that it's not posturing, it's not even a threat, much like a certain bar owner would think it was, but it cites controlling statutes, regulations, including 28 CFR 35.101, 35.130, 35.160, and 35.164, along with 42 USC. I don't know what those double S's are, but they're like 4S together, but 12202 and 12203. It explains that the city's obligations clearly are set forth and explains what happens when those obligations are ignored. Most importantly, the big thing is it explains when the city hall. It explains something City Hall seems to struggle with. Defenses like undue burden or fundamental alteration are not retroactive. If you don't assert them timely, you waive them. You can't ignore an ADA request and then later claim you were thinking about it for the whole time before that. Silence does not preserve defenses. Silence destroys them. My formal ADA Title II notice violation documents the pattern in detail. It documents repeated notice a year ago, documents the city's failure to engage a year ago. It documents the incident in which Safety Service Director Ray Carrion confronted and yelled at me, a disabled attendee, in the public meeting in April. It documents the lack of corrective action afterward. It documents what Ray did back in the previous month of August, September, when he went after me in a city council meeting and yelled at me. And that's what, not Ray, what's his name? Joel. So Joel came off on me during a city council meeting where he was acting president, not pro tem like Mr. Demakia. Well, the problem is that none of this is disputed. Has been with evidence. None of it's been meaningful addressed. It simply just sets on the record. And I can't see letting these vehicles sit there for no reason. So yeah, I know what estoppel is. None of that requires bad intent. The ADA does not require animus. It does not require hatred. It doesn't require smoking gun, email. All it requires is failure. Failure to respond, failure to engage, failure to accommodate. And this is not an edge case, so to speak, right? It's not a close call. It's exactly the scenario Title II was written for. And once again, we see the same pattern. A citizen who would never be allowed to ignore federal law for a year and then claim confusion. They wouldn't let us do it, right? None of you could do that. But when the violator is the city itself, the delay becomes strategy, silence becomes posture, and accountability is treated as optional. That's not how the ADA works. That's not how the courts read records like this. And in this case at least, if there's still any confusion, this is not a city that proactively complies with the law. This is a city that reacts only after being cornered by it. Nothing happens until the letter is sent. Nothing moves until someone puts a citation in bold. Nothing changes until exposure becomes unavoidable. Accessibility is treated like a nuisance, not as a duty. Compliance, treated like a favor, not a requirement. Accountability, treated like something that only applies once the spotlight turns on. Now, that's not proactive governance, folks. That's damage control with the seal and the letterhead. And it's sad because it allows people to continue to do what they do. We're going to, in our next segment here, we're going to get into a little bit of the value speech. Oh, God. Yes, I see it. So, Mayor Bradley gave his little value speech. It didn't really exist in isolation. It can't really be evaluated on tone or intention alone, right? It has to be read the timeline that's forced into existence. So when that's done honestly is the speech stops functioning as a declaration of principle and starts functioning as more of a response to exposure. By the time the mayor chose to invoke his respect, inclusion, professionalism, and disability awareness statement, the city had already been in possession of multiple ADA notices, right? Had acknowledged the receipt of those notices and still failed to take any meaningful action in response. That context matters, folks. And it matters for a reason. Because the federal law, values are not underrated. At least values are not assessed by what is said after the fact, but what is said and done once notice is received. The speech did not predicate the conduct, it followed it. So December 8th meeting, when makes that whole point unavoidable. The meeting was not framed around accommodation or accessibility. It was framed around control, enforcement. It was also around, hold on a second. Why ain't that just weird? All right. But the repeated emphasis, like when we talk about all this stuff, when we talk about what happened with Joel and all this stuff, we go back to the context, right? And the speech Bradley gave didn't really say me by name, but the meeting was not framed on or around accommodation or accessibility. It was framed around control, enforcement, compliance with their authority. Well, the repeated emphasis on sitting down, which is what Joel told me that one night, and doing what one is told, as Bradley said in his speech, limiting participation and expanding the removal mechanisms, that a story that directly contradicts the later rhetoric about dignity and inclusion, right? Or even the earlier rhetoric. They read it before. If you ask me, I think that what they read was off a blanket that used to cover up the old rules that were horrid. That being said, what it does is all this tells a story that directly contradicts the later rhetoric that dignity and inclusion matter. That these are themes that did not emerge accidentally. They didn't come without provocation. They emerged with while an acknowledged ADA complaint from me sat unresolved, and at the second Title II notice with the deadline of being ignored. Same thing for another gentleman. We had two of them in the courts at that time. The courts were evaluating ADA claims. They do not isolate speech from conduct. They examine patterns. They ask whether a public entity engaged in the interactive process, whether reasonable accommodations were considered, and whether the corrective action was actually followed with notice. In this case, the record shows escalation rather than correction, silence rather than engagement, and procedural tightening rather than accommodation. Now, a value statement issued after the sequence does not mitigate that liability. It actually documents the awareness without cure. It documents the awareness without cure. It definitely documents the awareness without cure. Because the careful construction of the mayor's speech goes further. It underscores the problem. It avoids names, dates, acknowledgments, error while speaking in a broad moral term. The distance not accidental. It reflects an effort to appear responsive without conceding responsibility. But under Title II, that intent's irrelevant. The, the, the question is whether the city acted once it knew. The question and answer is based on the records. Did it or did it not? That's what makes the value speech particularly damaging for the city, is that it confirms knowledge at its highest level, but by the time it was issued, the leadership clearly understood that disability issues were in play, and the federal government and law, which covered their response. Yet the actions that mattered the most had already failed to occur. Accommodation was not offered, communication was not restored, and the interactive process never happened. So, what arrived instead was rhetoric. In the end, the speech does not rescue the city's position, it weakens it. It stands as evidence that leadership knew what the law required and still chose to the issue to look at it through certain optics rather than compliance. So, under the ADA, that distinction is not academic. It's a difference between lawful governance and actionable violation. Values do not collapse because they are spoken poorly. They collapse when they are spoken too late or after the record has already been told in a different way. Um, you know, we roll into Sheffield Lake and we start to realize what happened was there's this revolving door policy that's going on. It doesn't stay in Lorraine. It kind of floats around. And the same small circle of names keep popping up all the time. Assumptions keep reappearing. And it's this not, God, it's just one jurisdiction over and over and over dressed up as ordinary government staffing. Think about that. Now, we talk about the revolving door a lot, which means you're not supposed to take a government job in the same area you were in, depending on your skill set for over a year. Yeah, you got someone that's the administrative assistant taking over. No, I'm sorry. Somebody that's working on the city council now is going to take over chief finance officer, where they're currently chief financial officer over the board. How is that not a conflict of interest? All right, whatever. The problem is that we look at Sheffield Lake and this cluster problem they have is like revolving doors, is that what happened in Lorraine just doesn't stay in Lorraine. That same small circle of names, practice, and assumptions keep reappearing everywhere, right? Not just one jurisdiction overdressed as an ordinary government staffing. When people hear revolving door, they sometimes get a picture of a generic, distant phenomenon, like Washington lobbying for, are you watching what's here is smaller, lighter, tighter, and more personal. It's the local version, so to speak, where the public's legal institutions start to feel like a traveling show, and where the cast swaps costumes, changes buildings, and sort of keeps the same play. In the December 8th meeting transcript, you'll hear that officials spend a long stretch of discussing how much they can control, how much they can identify themselves, how to police disruption, how to structure warnings to build them courtroom proof, right? And that's and like the way I look at that is this makes me mad. It grows in a system where public legal offices are treated as flexible interests and instruments of convenience rather than what they're supposed to be, which is the restraint mechanisms to protect the residents from government overreach. Not just the residents of the building, but all residents of the state. So we look at it and we go, all right, so it's your civic duty, right? So you start to see the pattern, the values, the language starts to sounding less like duty and more like institutional self-protection, because the same people who speak out about civility and the procedure are also the same people who decide against the House and the spend limits, and money to defend conduct, and how records are handled, and how aggressively rules are used against dissenters. All I know is that now we take that lens, we look at Sheffield Lake. Even in the routine council records, you can see the legal office as a whole and as a central node in Sheffield Lake city operations. Sheffield Lake council could pack it from 2012, for example, and include, I don't know, a law director's report, so to speak, where the law director, I guess now it's not Graves, but Levesque. Sorry. And he is basically reporting on settlements, documents being signed, legislative items expected to come forward. The city of Sheffield Lake, Ohio, at that point, and the point is that it's not the law director that should be involved in city business, so to speak. At that point, that's when legal authority needs to come to the hinge on which everything swings. The integrity of that office becomes the difference between a city that is restrained by a law and a city that is used or uses law as a weapon. And this is where like that revolving door issue becomes an issue, an ethical, like structural issue rather than gossip. Public law offices are not private consulting shops. In Ohio, municipal law directors are not hired to play for favorites. They're not to serve as political armor. They are not charged with representing the municipal corporation. Wait, they're not? No, they are. That's right. They are charged with representing the municipal corporation and performing defined public functions. That's it. The revised code itself frames that office in institutional terms, meaning the role exists to serve the city and the entity, whether or not faction happens or whether happens to have a microphone. Ohio laws when the same names rotate through neighboring jurisdictions, when professional relationships overlap, when the same lawyers keep showing up at the same moments, residents reasonably start to ask questions whether accountability is being enforced on merely management. So, what makes it work than the small town networking? More so? What is that? Everybody knows everybody. And that's always the main excuse in local government to figure things out. Everybody's like, oh, the real issue is not whether officials know each other. The real issue is whether those relationships are producing observable outcomes that are hostile to transparency and hostile to equal access. So let's look at that December 8th discussion treats the public. There's an obsession with control mechanisms, time limits, warnings, removal, prosecution thresholds, identification requirements that are discussed like tools of management, because residents are told, if you want to know what happened, you can file public records requests. If you want to know what happened, you can ask them to give you the reports, even as officials complain that the records requests are burdensome. That's not like a value system, that's a containment system. And when the mindset meets a revolving door, legal culture, the result is predictable. Residents do not have time to just break free and face a single official. The face of an aligned network of institutional actors is already sharing the assumptions about what the disruption means, what order means, how to frame challengers. The system does not do well with a need for an explicit conspiracy, so to speak, waiting in the back room to function as a coordinated apparatus. All it needs is repeated professional alignment, repeated mutual enforcement or reinforcement. The Ohio standards that matter here are the ones where the legal and ethical frameworks matter because it's not about vibes. Ohio law does not treat public office as personal benefits program. Ohio ethics rules that public officials are prohibited from using their position to secure anything of value, and they should prohibit conflicts when they conflict. Public office or authority is, oh wait, that's not you. You're just, okay. It's a statutory way of hearing that public money and public contracting cannot be steered into rearrangements that violate conflict of interest boundaries. This does not mean that every hire is illegal. It does, however, mean that the public is entitled to demands bright line transparency. Whatever else you need here, because where appropriate, because the law recognizes that the harm that comes from blurred rules when citizens see the same lawyers or officials appear in those repeatedly across related controversies, the burden shifts from an institutional one to prove separation, not to a public one to pretend it's all coincidence. So this connects back to your guys' culture with the ADA here at the facility that you're at, and then the timeline and the sit-down culture that was more or less cleared before they went after the young man. And I sent an ADA request in back in 2024 in September after being targeted and singled out by Mr. Joel. And basically, a sit down moment was all that occurred. Now, to this day, no one had ever tried to explain anything to me. And when I went back, my report still set. So, okay, I got you. During that time, sure, we can go ahead and cook it up. We look at the way life was at afterwards. A value statement appears dressed in a language that a disability and inclusion are included and inclusive, and we receive acknowledgement that the receipt is done, and life is what it is. So here's where it matters in this segment is that a genuine understanding of the system produces operational challenges. It produces timely ADA engagement, documented interaction, process, consistent treatment of disabled residents, and retaliation. I came in twice. A public relations value system that produces speeches, procedure, tightening, and optics documents posted after the fact, while the underlying control remains the same. And this is where the Sheffield Lake cluster, so to speak, fits in the narrative. When a public legal culture becomes portable, well, then the same logic of the control and the defensiveness travels with the document. So, are you really not transferring one to the other? I don't know. Well, anyway, the target changes, the rules, the language changes, the power moves. The power move stays the same, though, because that structural failure conclusion, so to speak, is not personal. It's a structural failure. It looks like this. The government acts like this. And as a problem to be managed instead of right up respected, legal offices will typically become shields instead of guardrails. Procedural becomes a substitute for accountability. And staffing patterns across the neighboring jurisdictions start to feel less like public service and more like network maintenance. And if you want the public to trust them, us, then, and if they want that, the remedy is not another speech. The remedy is documented separation, documented contradiction, and a little bit more, I don't know, everything. But until then, we can look at, hopefully we'll have consistent compliance with disability access obligations without delay tactics. And we'll start to recognize that same pattern because it'll keep repeating itself when the same cast is just in different cities. And in the grand scheme, we look at it and we go, the final layer to the whole story is that just most people will never ever see what goes on behind the camera quietly. The institutional walls that are supposed to exist for one purpose or another, that's where accountability is set. That's where it happens. That's where the documents are sent. That's where the notices are served. And that's where timelines are laid out. And that's after the record's complete. The auditor of the state receives these materials. The attorney general receives these materials. The civil rights agencies receive these materials. Oversight bodies that exist. And specifically to intervene when local government fails to actually act on the notice. And that's hard. So with that being said, all we can say is that attachments, citations, and paper trails that are not required as speculation or interpretation. So they're not vague complaints. They're documented events. I need you to make sure they're in order. And then we look at them and we go, all right, so we got engagement letters, meeting transcripts, ADA notices, acknowledgement receipts, and then the most uniformly, as always, nothing happens. When it first comes back, it's anything but silence is framed as a process, deflection is framed as a jurisdiction, and blame is shifting. Blame is framed as neutrality, One office points to the next, another claims its lack of authority, another acknowledges blah, blah, blah. Quietly, we all close in on that authority without explanation. The result's always the same. The conduct will remain unaddressed, and the officials, us, and people around us will remain insulated, right? Nobody's got anything to just give a boost to the engine system after all this time on the seat. So this is where the system starts to reveal itself. And it's the most dangerous feature because it's not just local government that's failing. It's the accountability ecosystem itself. When the state itself doesn't feel like it's doing it, then how can they hold us? How can they ask, I don't know, state level actors to decline to act on clear records of misconduct? They're not really remaining neutral. They're ratifying the behavior through inaction. I don't know. I mean, this is one of those areas where it's like, do you do it or do you not? But the signal's not ignored. And for approving conflict defense arrangements, I would say treating residents differently than the law requires. That contrast is impossible to ignore. And if a citizen disrupts a meeting, charges are discussed, protocols are refined, and prosecution is debated at length. If a disabled resident fails to comply instantly with an order to sit down, enforcement mechanisms stop that focus. But when officials ignore 88 notices, the acknowledgement is not just on the door, right? It's approval, legal arrangements, and co-defendants. And, or so to speak, publicly in the ways that exasperated violations happen. We should just, and that's why people get confused about it. They don't know what's going on. Like, whoa, what was that? All right, well, I got you. Oh, sorry. I was trying to find the rest of this. My bad. Well, folks, look, that's going to be the end of it tonight. I had one more little piece on here I wanted to throw on, but that part kind of got chewed up a little bit. The bottom line is what I'm looking at tonight is I'm looking at what they're doing. I'm looking at what they're doing over at with Rosenbaum, what they're doing with all these different people, and it's just crazy. And I keep seeing the same crazy stuff over and over again, conflict after conflict after conflict between individual after individual after individual. And while I'm not really supposed to talk about my case tonight because I can't say a whole lot, and that was kind of where I was at with this whole idea, is that I can't really say a whole lot, right? But what I can say is this. I can say that let's see. I can say this last little bit here before I go. And what we can say is that when you look at individuals who are co-defendants, it doesn't work out well, right? These guys are all tied together in one way, shape, or form, and that's not okay. Because you see these ties. That's where the system reveals its most dangerous feature. It's not that we're failing and the government's failing, it's that accountability is gone. All these state level actors decline to act on clear records of misconduct. The police don't act on anything, and they're not remaining neutral. They're ratifying the behavior through inaction, and they're signaling to local officials that there is no meaningful like consequence for their actions, or for ignoring the federal disability laws, or for approving conflicted defense arrangements, or for treating residents differently or than the law requires. The contrast is impossible to ignore. If a citizen disrupts a meeting, charges are brought or discussed immediately. Protocol is refined, and prosecution is debated at length. If a disabled resident fails to comply, instantly with an order to sit down or some sort of enforcement action mechanisms snap into force. When the officials ignore ADA notices, they acknowledge receipt without compliance, they approve legal arrangements for co-defendants, or speak publicly in ways that are exasperating the violations. And that response from the state is supposed to be patience, deference, and procedural perilous. But the double standard is not accidental, it's structural. The message being sent is clear. Even if no one puts it in writing, rules are enforced downwards, not upwards. Compliance is demanded of the public and not officials. And that's the problem, because it comes inconvenient and then it quietly disappears behind the jurisdictional language of unanswered emails. And in the grand scheme of things, what we continue to see is the same thing. Forwarding documents matters to these people. Even when it appears like it doesn't matter, it removes the plausible deniability they all think they have. It creates a record that the state actors knew, were informed, or chose not to intervene. And that choice carries consequences of its own, because it teaches every local official watching exactly how much risk they are actually taking on when they ignore the emails and the law. This episode exists because of that silence. It exists because accountability mechanisms that look robust on paper have proven fragile in practice. It exists because when the same conduct is punished in citizens and excused in officials, the problem is no longer just one city, one meeting, one dispute. It is systematic failure that only becomes visible when somebody refuses to stop documenting it. And I'm not going to. And that's the point where the story no longer belongs to the city alone. It belongs to the state that looked at the record, looked away, and allowed the pattern to continue. So what ultimately matters here, folks, is not who spoke the loudest, but or mocked the hardest, or tried to trivialize the most serious facts. What matters is what exists in writing, what exists on video, and what exists in medical documentation. The podcast response that followed my attorney's letter. This is the area where I'm going to be cautious about what I say. But the podcast response in Madhouse that followed my attorney's letter to them, it didn't resolve anything. It didn't clarify responsibility. It didn't dispute the existence of injuries. It didn't explain why no police were called, or why untrained patrons were used as de facto security, or why a disabled individual was allowed to be crushed under the weight of another person, right, during a violent incident. What it did instead was it acknowledged the receipt of formal notice, and they chose to ridicule it instead of giving it accountability. And that choice matters, because once notice is given, conduct from that point on is no longer hypothetical. It becomes part of the record. Publicly denying responsibility while minimizing documented injuries and omitting critical facts does not make those facts disappear. All it simply does is sharpen them for the later review by the people who do not operate on podcasts or personalities, but on evidence. And for that reason, continuing to litigate these matters in the media is not productive for me, so I'm not going to talk about it. The facts are already fixed. The injuries are already documented. The failures are already visible. And that's why the appropriate next step is not commentary from me, but process. Complaints are drafted in pleadings, not monologues. Accountability is established in filings, not mockery. And responsibility is always determined by evidence, not bravado. So the same principle that applies to the broader pattern discussed throughout this episode, whether it applies to conflicts of interest or it applies to misuse of authority, ignored ADA, obligations, or selective enforcement areas, the issue is never done. The issue is compliance. Trust is restored by speeches, statements, or reactions after the fact. Never. Trust is actually restored when officials and institutions follow the same rules they enforce, respond to the same law that requires a response, and correct misconduct when they're forced misconduct before they're actually forced to do it. But until that happens, this work's going to continue. Not because I have a personal grievance, although most will see I do have somewhat of one, but because public accountability does not exist in a bubble or without persistence. Unplugged, this show, exists to document what others would prefer remain fragmented or dismissed. And it exists to preserve timelines, correspondence, and records so the truth is not dependent on memory or power. This is the record. So after my attorney sent the formal letter to Mr. Tucker, the recipients did acknowledge receiving it publicly on their podcast. Beyond that acknowledgement, I'm not going to dissect or debate their commentary, including Tia's, on the advice of my counsel, because this matter is no longer something I will litigate on air. The facts, the injuries, and the failures are documented, and they will be addressed through proper legal process. That being said, thank you guys for tuning in tonight. I want to thank you for tuning in. This is Aaron Knapp. I want to thank you guys for all being here. Law enforcement, be lawful, not awful. Everybody else out there, have a good weekend, man. Enjoy yourselves. Try to stay warm. Try to stay safe. On a side note, I will say this. If you think I'm getting my information from one particular party, maybe you think it's Garen, maybe you think it's Bob. Maybe, tonight on the podcast, they were like, well, everything Aaron says is from Bob. Well, no, it's not. I do have my own lines. Trust me. I don't get information from Amber, from Bob, from anyone. If I'm talking about somebody's business, you can guarantee that I've received it from at least 3 to 5 people before I speak on it. And when most of the things I speak on, I oftentimes will say, aren't they? Maybe they are. I'm never insinuating anyone is anything because I don't know. So just know that, guys. Thanks for tuning in tonight. Enjoy yourselves on this Saturday night, and we'll see you guys next time. Thanks.